Okay, part two of the Manhattan DA's response to defendants' omnibus motion on the Luigi Mangione case. Sorry for the delay, and I changed because I just filmed a law and crime episode. All right, let's get back into it. The last we left off, we were talking about why the terrorism charge is not going to stick, in my opinion. So again, in order to prove the terrorism element of murder in the first degree, and I brought this up on my little laptop so I can read the exact definition to you, the Manhattan DA's office is going to have to prove beyond a reasonable doubt that he either intimidated or coerced a civilian population, or he influenced the policy of a unit of government by intimidation or coercion, or he affected the conduct of a unit of government by murder, assassination, or kidnapping. And again, the DA's office is claiming that they are able to hit all three. One of the questions that I think some people had are like, why did the motion mention that Brian Thompson was wearing a Rolex watch and that Luigi didn't take it? It's the same reason why the motion mentions that Luigi didn't say anything to Brian Thompson before allegedly committing this act, nor did he have a personal vendetta against Brian Thompson. What they're trying to say is that this was a terroristic intent, that his intention was to coerce or intimidate a civilian population or to affect like governmental decisions, rather than this being a typical street crime where, you know, it's retaliation or gang activity or a robbery. Now, I think Joel Seidman spends way too long talking about the terrorism charge, and I know why he did it, because he really wants to try to convince the judge not to dismiss his count. But I think the amount of attention that he puts on it kind of goes to show how flimsy it is. Like, thou doth protest too much, basically. So, for example, he spends a whole lot of time in this paragraph saying, defendant's intent is obvious from the natural and probable consequences of his acts. And he goes on, to talk about how they brought like United Health Group employees to the grand jury to testify about how people, felt intimidated or even quit their job, or how one woman like even dyed her hair and moved to a temporary house. So personally, I don't find it convincing. Remember, in order to indict somebody in a grand jury, the level of proof that you need is basically reasonable suspicion, probable cause, like the same amount that you need to arrest somebody. That's very different from a conviction where you need proof beyond a reasonable doubt. Interestingly, he even includes in his motion the fact that some random stranger was calling some of the United Healthcare employees saying like, you're going to hang. Brian Thompson's killing was just a start. I thought that was kind of an interesting strategy because, can't you just turn around if you're Karen and be like, well, maybe that guy is the shooter? Like, I just didn't think he needed to put that in there and so doubt. Another thing that stood out to me was that Seidman was saying that murder as an act of terrorism does not require the murder of multiple victims. And then he went on to describe a couple of different previous cases that were deemed terrorism where only one person died. I thought he was super off base with this. He spends a lot of time talking about how it could just be one person, but then he cites something on page 21 where he says those federal anti-terrorism statutes were in turn, quote, designed to criminalize acts such as the detonation of bombs in a metropolitan area or, and he bolds this, the deliberate assassinations of persons to strike fear into others or to deter them from exercising their rights. So that's multiple people. So I don't know why he did that. I mean, it kind of goes against his argument. And then again, the cases that he cited to, that being the 1994 murder of Ari Halberstam on the Brooklyn Bridge and the 1997 shooting on top of the Empire State Building, don't really support his assertion. As an aside, it's like very jarring to read that because I work a lot in Brooklyn and cross the Brooklyn Bridge. And actually that ramp leading up to Brooklyn Bridge is named also like Ari Halberstam. I don't know if it's road or street or whatever. It's literally named after him. And so when I saw the name, I was like, oh, I know that guy somehow. Anyway, I think that his citations to those two cases are totally misplaced because, first of all, those two, the individuals who were targeted in both cases One could really argue that it goes by Karen's definition of a civilian population, meaning it is a protected class. The van of Hasidic Jews who were coming up the Brooklyn Bridge are a minority group that is protected, and it's a like very set class of people. Similarly, the Empire State Building, the person who committed that crime stated that their intent was to kill people like Americans, who else? British people, French people, and Zionists, saying that they were responsible for turning our people, the Palestinians, homeless. So again, there was like this terroristic bend to it. Whereas if you're just a worker in United Healthcare, like you could be a worker at United Healthcare today and not a worker at United Healthcare tomorrow if you quit. Like a person who just happens to work in that company, like even as an executive, that could be your job today and not tomorrow. Like I just don't think that that is a defined civilian population. I do not think that it meets the requirements. And secondly, and probably more importantly, I really disagree that this is about murdering one person, because in both of those cases, the Brooklyn Bridge and Empire State Building cases, only one person happened to die, but the perpetrator was shooting at and trying to kill multiple people of that very same class. A van full of Jewish people and like a whole bunch of people on the Empire State Building. And other people were in fact injured in both cases. So just because the perpetrator wasn't successful at killing more than one person in those two cases doesn't mean that they specifically targeted just one person. And so I think that with Joel Seidman saying that that you can apply the terroristic element to murder in the first degree to a situation where only one person was killed, I just don't see it flying here, because if you're going with respect to intent and what somebody intended to do, then those two other people from the 90s, they intended to kill a whole bunch of people, whereas Luigi, or the alleged killer in this case, only intended one. And as for influencing a governmental unit, I think that's also tenuous, because with all of the writings in the manifesto and everywhere else, you don't necessarily make that connection to trying to affect a governmental unit. You could still argue that he was just simply trying to make a point, an aggressive point, and a headline making point by targeting this one person in this one place and event, but it doesn't necessarily jump to trying to influence a governmental unit, not beyond a reasonable doubt. Now, I do think that Joel Seidman does score some points with the double jeopardy argument. He kind of calls Karen out on some hypocrisies, I guess he would probably say. Number one, that she jumped up and down, up and down, up and down in the beginning of the case about efficiency and moving the case forward as fast as possible, but is now basically saying that the state should hold off and let the feds do their trial first, knowing, she even acknowledges, that a trial in a federal case like this is going to take years to come to fruition, whereas the state is like ready to try this case ASAP. So how is she arguing that, the state didn't turn over enough evidence fast enough and, we want to do this quickly, and now she's kind of saying, actually, we want to back up and hold off. And he basically calls her out, saying that there is one area where double jeopardy could potentially apply, and that is if the federal prosecution does in fact go first and he gets convicted after trial. There are some situations where at that point the state would not be able to prosecute him. I'm just going to pause here for a quick second to give a quick shout out, because I did not realize that the judge who signed the arrest warrant in New York for him in Altoona was Mike Ryan. Mike Ryan was my supervisor when I was a little baby prosecutor at the Brooklyn DA's office, and now he's a judge in Manhattan. And I just want to say, boo on you, Mike Ryan. Why did you sign that arrest warrant? No, just kidding. He's actually amazing, and he was like one of the best supervisors I've had. So, hey, Mike. But Seidman scores the slam dunk essentially when he quotes Karen's motion saying, defendant claims that the concurrent prosecutions involving conflicting theories, the state focusing on terrorism-related charges and the federal focusing on conduct targeting a single individual, essentially undercuts her entire theory that it's double jeopardy. In fact, it proves that the two jurisdictions are prosecuting two different evils. So I think that was a little bit of a slip up or a snafu on Karen's part. Anyway, that concludes part 2. Leave me more questions if you have. I'd be happy to answer them.